who you are, including your name and what organization you're representing or point of view or constituency. And anytime you speak, we just ask that you begin by sharing who it is that's speaking. With that, I want to just give a quick overview of today's meeting, and then we'll go ahead and dive into it. It's really about picking up on that last conversation we had with everybody. And as you'll recall, when we were last together, we started meeting on our first conversation, really talking about what were some of the misperceptions and what are some of the hopeful aspirations that everybody has. And then in our last meeting, we started talking about the reports that we have to undertake and really the work that we have to do to help rewrite CADA as outlined in the statute or the legislation that created this working group and this task force. And each member had an opportunity to share where they saw there was particular need. And we talked about things broadly, all needs that we saw, as well as kind of drilling into when we look at the reports that we've got to write, the first one in December, we'll identify if there's any, what I will describe as low-hanging fruit, but maybe some of the simpler things for us to identify and come to consensus on. And then we're also identifying where the issues are a little more complex, potentially a little more contentious, or just really more detailed and nuanced for us to be able to spend the time, and likely will be more of the subject of next year's report. So we're going to spend some time reviewing that short list today, and I will read it out. You should have also received it in your agenda, but I'll read it as we go. Before we do that, though, we're going to have a presentation and a conversation with representatives from the Attorney General's office. A couple of things that I want to flag, and you're going to hear me say this throughout this subcommittee's work when we ask lawyers to offer us their thoughts on a law. Understand that none of these lawyers are here to provide us as a subcommittee legal advice. And if those of you who have dealt in the legal profession or are lawyers yourself, you know that there will be as many opinions and interpretations of any piece of law as we can get on the phone. And in my experience, the same lawyer may even give us two opinions if we invite them back a second time. So know that we're going to do our best to bring as diverse a takes as possible. So throughout this process, we're going to be asking each of you, for example, to share your ideas and your understanding, but also to identify different folks that have been involved, whether they're as lawyers, plaintiffs, defendants, or otherwise, with their perspective of the law. For today, it's really about just a grounding conversation with a representative from the AG's office. As we go forward, we're going to continue to work with all of you, as well as with Representative Ortiz and Lieutenant Governor, to identify additional experts. If we do get to a point where you guys have a question about law, we will do our best to go get different takes on that. But again, I've got to emphasize, we do not have somebody who is providing us, serving in the capacity of providing legal advice to this subcommittee. So we'll have a lot of conversations about interpretations and opinions, and we'll try to ground it in fact. Does anybody have any questions about what we're going to be trying to accomplish today, or all of those 27 disclosures I gave to our conversation about the law? Okay, well then, hearing none, Jenna, I'm going to throw it over to you.
Thank you so much. I appreciate everyone's time today and letting me speak. Give me just a moment. I'm going to try to share my screen. I have some slides. Bear with me. And it looks like I'm unable to do that because I'm not a host. Is there another way to get my slides or to be made a host? And I'm sorry for this logistical issue. Oh, there we go. Okay, give me just 1 second.
And while she does that, I do just want to name that you saw on the agenda an item for meeting two reflections, and we are going to come back to that. I wanted to give Jenna the time to go first in our conversation.
I appreciate that. Thank you. So I am trying to share. Can everyone see the first slide in this? Excellent. Thank you. So my name is Jenna Anderson. I work at the Colorado Attorney General's office. I'm here today to provide an informational overview of CADA, the Colorado Anti-Discrimination Act. As we get started, I have even more disclaimers for you to hear today. Really want to make clear that this presentation is intended to provide all of you with a broad overview of CADA and does not provide any sort of legal advice. And I'm not, in being here, I'm not a spokesperson for, nor do I represent any governmental entity within the state of Colorado. nor do I represent the ideas, determinations, or conclusions of the Office of the Attorney General. And I'm not able to answer any kind of questions today that might arise from the information that I'm presenting. So with that, we'll go ahead and I'll get on with my kind of very broad overview.
And Jenna,
So
I'm sorry to, Jenna, I apologize for interrupting. You and I didn't get a chance to connect. I just want to make sure you're aware because some of our folks are using screen readers, both members of the subcommittee or folks who may be streaming at home. So if I could just ask you to read each slide as the screen share doesn't allow their screen readers to interact.
Of course. So
Thank
this
you.
first slide, the title is CRS section 24-34-301. The Colorado Anti-Discrimination Act, also known as CADA, CADA, prohibits discrimination in the areas of employment, housing, and places of public accommodation. So these are the three areas that CADA works in. First, I'm going to talk about the employment section. So the title of this slide is Employment, CRS section 24-34-400. The legislative purpose given in this section states that all Coloradans should have an equal opportunity to succeed in the workplace and are entitled to a workplace that is safe and free from discrimination and harassment based on their protected status. There's also a note on this slide that complaints must be filed within 300 days of having received notice that the alleged, I'm sorry, I need to look, discriminatory or unfair employment practice occurred. And so that received notice is either received notice or should know that that had occurred. So we have some key definitions here in the employment context. CADA defines employee as meaning any individual employed by an employer. And that comes from section CRS section 24-34-4012. I'm going to move my camera just a bit so I can read in a smoother way. The definition of employer, as also written on this slide, means the state of Colorado or any subdivision, commission, department, institution, or school district thereof, and every other person employing persons within the state. But it does not mean religious organizations or associations, except such organizations or associations supported in whole or in part by money raised by taxation or public borrowing. And this is in CRS section 24-34-4013. So when we're talking about the protected classes that CADA provides in its employment section, we are looking at these several employment protected classes. Those are disability, age, within this means 40 and older, race, color, national origin, ancestry, religion and creed, sex, marriage to a coworker, pregnancy, retaliation, which means engaging in a protected activity, such as filing a complaint of discrimination, complaining of harassment, based on membership in a protected class. Other protected classes are sexual orientation, gender identity, gender expression, and marital status. And that could be either are married or not married. And this site comes from CRS section 24-34-402. The next slide is titled Discriminatory Employment Practices. And so this is a listing of all the different types of employment practices that are prohibited to be taken taken based on those protected classes that I listed out before. So this is a failure or refusal to reasonably accommodate a disability, a refusal to hire, discharge, failure to promote, to demote, harass, unequally apply terms and conditions of employment, unequally compensate. And underneath that, it also states that employees are permitted to inquire about, disclose, compare, or otherwise discuss employee wages amongst one another. Retaliation is also prohibited, as is printing or circulating any statement, advertisement, or publication that expresses either directly or indirectly any limitation, specification, or discrimination as to a protected class or classes. And that comes from CRS section 24-34-402. So that's employment. Let's go ahead and turn towards housing. And the housing part of CADA is listed under CRS Section 24-34-501. I'm sorry, I have CRS twice there, just in case you forgot. It was part of the Colorado revised statutes. The filing deadline for housing under COTA is within 1 year after the alleged unfair housing practice occurred. The definition of housing within COTA is any building, structure, vacant land, or part thereof offered for sale, lease, rent, or transfer of ownership. And that's within CRS section 2434-501, section 2. So let's go ahead and talk about the protected classes under housing. You'll see that many of these follow along with what was in employment, but we'll see some additional and some differences here. So the first one is disability, race, color, national origin or ancestry, religion or creed, sex, marital status, familial status. And so that means a child under the age of 18 living with a parent or a guardian or guardians, a pregnant woman, or an individual in process of obtaining custody of a minor. Retaliation, similarly, which is engaging in protected activity, which can include filing a complaint of discrimination, complaining of harassment based on membership in a protected class. Also included are sexual orientation, gender identity, gender expression, source of income, such as perhaps housing vouchers, and veteran or military status. And this all comes from CRS section 24-34-502. COTA does have exemptions from the housing definition. And that is that single family homes can be exempt under certain circumstances if the private individual who owns that home owns no more than 3 single family homes. And anyone interested in that exception, I would direct you to CRS section 24-34-502 subsection 8, as it has the full exemption there for you to review. Also exempted would be housing designated as housing for older persons, are exempt specifically from the familial status protections. Similarly, I would direct you to go look at CRS section 24-34-502 subsection 7 for more information on that exemption. So the COTA lists several discriminatory housing practices that are prohibited to take based on a protected class. Those would be refusal to rent or sell or otherwise make housing unavailable, to misrepresent the availability of housing, to apply unequal terms or conditions of sale or rental, a refusal to allow a reasonable accommodation or some other modification necessary to accommodate a disability, to impose some sort of restricted covenant based on a protected class, intimidation, or threatening or coercion, or other form of harassment, or to advertise with a discriminatory preference or limitation, as well as retaliation. The third and final aspect of COTA would be the public accommodation. And these statutory provisions can be found under CRS section 24-34-601. And this defines a place of public accommodation cannot refuse, withhold from, or deny to an individual the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations based on a protected class. And that is, again, from CRS section 24-34-601. And that filing deadline is different from the others and is within 60 days after the alleged discriminatory act occurred. So let's talk about the key definition here in public accommodation cases, which is what is a place of public accommodation? CRS section 24-34-601 subsection 1 defines a place of public accommodation as any place of business engaged in any sales to the public and any place offering services, facilities, privileges, advantages, or accommodations to the public. There are exemptions within the statute that come under the same provision, CRS section 24-34-601(1). Those exemptions would be a church, a synagogue, a mosque, or any other place that is principally used for religious purposes. I also have a listing here of public accommodation protected classes. Those would include disability, race, color, national origin or ancestry, creed, sex, marital status, again, retaliation, which is that engaging in protected activity, such as filing a complaint of discrimination or complaining of harassment based on a membership in a protected class, sexual orientation, gender identity, and gender expression. This is from CRS section 24-34-601, subsection 2. So let's talk about what CAUTA prohibits in terms of discriminatory public accommodation practices. These would be a refusal of services, a refusal to sell goods, unequal terms and conditions, disparate impact, disparate treatment, steering, segregating, or isolating based on a protected class, or printing or circulating any statement, advertisement, or publication that expresses, either directly or indirectly, any limitation, specification, or discrimination as to protected classes. And this comes from CRS section 24-34-601. I wanted to end my presentation with an overview of how CAUTA defines disability. So the title of the slide is called Definition of Disability under CRS section 24-34-301. This states that as used in parts 3 to 10 of this article 34, several of which provisions we've been talking about, unless the context otherwise requires, subsection 7 states that disability has the same meaning as set forth in the Federal Americans with Disabilities Act of 1990. And that is in 42, the U.S. Code section 12101 at sequence, and its related amendments and implementing regulations. So let's go ahead and turn to the federal definition of disability under 42 USCA subsection or section 12012. Under this statute, disability means with respect to an individual, A, a physical or mental impairment that substantially limits one or more major life activities of such individual, B, a record of having such an impairment, or C, being regarded as having such an impairment. The statute further goes on to define under subsection 2 what are major life activities. So in general, under A, major life activities include, but are not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. It can also mean, under subsection B, major bodily functions. So major life activity also includes the operation of a major bodily function, including but not limited to functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. The statute then goes on to explain under subsection 3 what regarded as having such an impairment means. And so for purposes of that, in that first section, 1C, regarded as having such an impairment means that A, an individual meets the requirement of being regarded as having such an impairment if the individual establishes that he or she has been subjected to an action prohibited under this chapter because of an actual or perceived physical or mental impairment, whether or not the impairment limits or is perceived to limit a major life activity. And B, this regarded as having such an impairment section, which is paragraph 1C, shall not apply to impairments that are transitory and minor. A transitory impairment is an impairment with an actual or expected duration of 6 months or less. And so that is my brief overview of CAUTA. I appreciate everyone giving me your time. I won't be taking any questions, but I do appreciate it. I hope everyone has a great rest of your day. Thank you.
Thank you very much, Jenna. This is Barrick again, everybody. And unfortunately, Jenna, we did have her do the presentation, but then dismissed from answering questions for the very reasons that I cited up top. We can't be putting folks in the position of rendering their opinion or interpretation. But before we go into reflections on our prior meeting, would love to just go around, and I'm going to ask folks to do one of a couple of things. Either react to something that you heard that was new to you or that stood out to you, or I'm going to invite everybody to just, in your most layman's plain language, how would you share to somebody in a grocery store if they said, hey, what is kata and what is the point of it? I see that Cindy's hand is up first, and I think Cindy's hand may have gone up before I put my questions on deck. So, Cindy, the floor is yours for whatever is on your mind.
Yes, thank you. I just actually wanted to ask while we were reviewing kata, if there is a specific reference around definition of accommodations. I'm thinking it refers to the ADA, but I just want to verify.
And as I'm not here to provide legal advice, I will let our lawyers weigh in with what, again, I'm going to emphasize is their opinion, not legal advice to the subcommittee. But Andrew, I see your hand up on the question of basic accommodation.
Yeah, thank you. And Cindy, please let me know if I'm not answering your question directly. But and I'm to clarify, I'm only speaking with respect to what is essentially Titles 2 and Titles 3. Ian, I might look to you for Title 1. But no, the kata does not actually have a definition for the phrase accommodation. And I don't believe the ADA has a definition for the phrase accommodation. It's more of like an interactive process sort of thing that, a lot of authority does describe what's required, but there's not an actual definition for that word.
Well, it does break it down by types of, I call it accommodations. There's probably a better legal word, but for example, communication access is one area, and that's where we get into interpreters and so forth. So what I'm wondering is, does kata refer to that for these types of definitions, or is this just not addressed under kata?
All right. So again, with respect to, public accommodations and public entities, it does incorporate federal law. So it does incorporate kind of the bulk of that, federal authority that describes that process and such. But that is one of the things that I personally would like to see come out of this committee is incorporating some of those standards into state law.
Incorporating some of the federal standards?
Yeah, exactly. Rather than simply referring to them, because those federal standards can change depending on, the judge interpreting them, the president appointing people to various agencies, things like that. So if we can enshrine those in state law and provide some, if not, greater than at least equal to, federal protections within state law, that's something I would like to see come out of this process.
And I'm glad you mentioned that, because the reason I've raised this question is that a number of things that are sort of delineated under the ADA are sort of behind the times, especially with certain groups such as deafblind. So that's an area I hope we can be more descriptive with as well. Thank you.
This is Barry. Thank you, Cindy, and thank you, Andrew. And I think that does certainly, when we get to the list of topics that folks have identified, I know aligning some definitions between kata and the ADA is something some members have brought up, as well as just bringing some clarity. And I'll just reground us in what we are charged with, which is to study the kata statutes concerning the rights of persons with disabilities and make recommendations for a thorough revision and rewrite to improve clarity, ensure the civil rights of Coloradans are protected, and ensure the protections are enforceable. So this is a pretty open table to all of you to identify what you think it means when we say to improve clarity and ensure the civil rights are protected, as well as that those protections are enforceable. So we'll keep it. Yes, Cindy, please.
Thing I wanted to verify. You may have already covered this, as I did come in a few minutes late, but I know that what we're tasked with is, kata rewrite. However, there may be recommendations that come out that may relate to suggesting in our recommendations other legislation. So are we sort of from the beginning setting up a little framework of here's recommendations for kata, here's recommendations for potentially other legislation that may be appropriate?
I think that's a fair question. And in full transparency, and this is Barry, we have not discussed that. Our specific charge, and I would view it as a floor, not a ceiling, is to recommend the thorough rewrite of CADA. If in the process, all of you identify areas that are necessary to protect the rights of Coloradans with disabilities, to provide clarity and ensure they're enforceable, I don't think there's anything that would prohibit us from offering those. Now, where those go and what the task force does, I'll go to the executive committee of the task force and come back to this subcommittee with an answer. But I think we should all approach this aspirationally and knowing it's unlikely anybody's going to raise the bar from what you recommend. So I would suggest that we reach high.
I appreciate that because I'm particularly thinking about enforcement. So I appreciate that.
Understood. Thank you, Cindy. And there may also be things that are coming out of some of the other subcommittees. And I think part of what we're going to have to do when we've got a subcommittee on public accommodations, and we've got one on outdoors, and we've got one on housing, we're going to have to do, and I say we, the task force itself, will have to do a crosswalk of where there are intersections of what recommendations any of them may offer that will be better served by combining and clarifying, so we don't create 4 different streams of recommendations that have any new contradictions in them. We're going to get in just a few minutes to our previous conversation, but whether it's reactions, reflections, or ahas from what Jenna shared with us, otherwise, what I'm going to do is go around the room and simply ask you, because I think part of our job is to be ambassadors to the communities you represent, to the constituencies and communities you're part of for this work to bring more perspectives to this. So I'm going to go around the room, and to make it a little easier, I am going to start with our lawyer friends. That means Andrew and Ian, you're on top right of my screen. I'm going to go to you for either reflections or just how would you, in the grocery store checkout line in 30 seconds or less, answer somebody when they say, so what is CADA? And Andrew, you're top right, so that means you're going first this round.
All right, thank you, Barrick. This is Andrew. I'm going to go with option A, which is kind of describing a little bit of reflection on the presentation. There seemed to be a bit of a glaring omission from that presentation, and that's part 8 of the CADA, which is specific to disability rights and disability discrimination, and it does incorporate public entities as a potential defendant against whom these claims can be brought. So considering that, as you highlighted for us, our charge is to discuss improving the CADA with respect to disability rights issues. The omission of Part 8, which touches and largely encompasses the disability protections, seem to be a pretty glaring omission, and I'd like to get a little bit more information for the benefit of everyone else in the group related to Part 8 of the CADA.
So we will bring that back then. I don't have an answer for you, Andrew, and Jenna has dropped off at this point. I know there are some issues with definitions there and their intersectionality with others, but we will see if we can't get a similarly black and white sharing of Section 8, to your point, and we'll certainly be including it in our discussion. Ginny, I see you coming off mute. Did you want to jump in?
Yeah, I was just going to flag that our Civil Rights Division does not enforce Part 8.
Yeah.
But that doesn't mean we still can't provide information, just that they don't enforce it.
Yeah, thank you, Ginny. This is Andrew again. I think that would be helpful, and I will also point out that there have been some investigations under Part 8 against public entities that I'm aware of, so it seems that we're in a bit of a gray area there.
Ian, I'm going to go to you and then to Lauren for reactions, reflections, or what the heck is CADA?
Sure. Thanks, Barrick. Ian Kalmanowitz. First with a reaction and sort of to follow up on what was Cindy's question and Andrew's answer. There are no definitions of accommodation in CADA. And I will say as a reaction that is a surprise. I mean, as somebody who works in the statute quite regularly, it's a surprise to me, but it's, I guess, not really a major surprise, because in the employment context, there's a specific provision that incorporates federal law when CADA is silent on things. The ADA in its Title I, which is the employment section of the ADA, has a pretty loose definition of what an accommodation, a reasonable accommodation is. And a reasonable accommodation may include A, making existing facilities used by employees readily accessible to and usable by individuals with disabilities. And B, job restructuring, part-time or modified work schedules, reassignment to a vacant position, acquisition or modification of equipment or devices, appropriate adjustment or modifications of examinations, training materials or policies, provision of qualified readers or interpreters, and other similar accommodations for individuals with disabilities. And that's out of the statute. The EEOC has regulations as well that provide more guidance about what may be a reasonable accommodation. So it's out there, but that's a place where it's not a model of clarity because one must look to multiple different places to be able to find it. And then in particular here, that's only in the context of employment, not in the context of housing or public accommodation. Your second question, the grocery store 30-second pitch on what CADA is. CADA is the State Anti-Discrimination Act. And so CADA is a robust statute that came into existence before anti-discrimination law at the federal level. And it prohibits discrimination in employment, housing, and public accommodation against individuals on the basis of race, religion, gender identity, gender expression, national origin, age, marital status, disability. I think I covered all of them. Creed is unique in CADA. That does not. It's not there's no equivalent protection under federal law for creed. And what this statute does is it protects people at work in trying to obtain housing, whether as purchasers or renters, and in places of public accommodation, so that we can all enjoy, our society and be vital contributors to it by working, living, and being out in public without fear of suffering any kind of discrimination because of any of these protected statuses.
Thank you, Ian. I'm going to go next to Lauren and then to Tom Aker. And again, takeaways or the what the heck is it?
Thanks, Lauren Schwartz speaking. Yeah, if I were chatting with someone at the grocery store, I would say this is Colorado's law to ensure you know your rights as an individual, that you have that you have the right to seek and maintain employment or housing, or to frequent any business that you like, that is open to the public, and that you will not be discriminated against. And what I've learned, well, I've learned a lot from all of you over the last couple of calls. So too many things to list. One thing that came to mind, I mean, just listening to Andrew on the last call, when he was talking about Texas codifying some of the ADA federal statute and state law. It was a big surprise to me. But I too many learnings to number. I'm learning from everybody.
Quite all right. Thank you, Lauren. This is Barrick. I see Courtney is on the phone. Courtney was caught up in court, and I know we may lose Ian to a conference in a little bit. It's one of the prices we pay for having these brilliant legal minds on with us. Courtney, we just had a presentation at the top of the call from the AG's office, a very black and white, here are what the sections are of CADA, with my big caveat that they were not offering legal opinion or advice. They were simply presenting it. And some questions were raised about why we didn't cover Section 8. We will get to that. It was flagged that Section 8 is one of the pieces that the Civil Rights Division does not enforce, but that does not mean that it's outside of the purview for this group to consider. And now we're just having a conversation about whether people took something away from it. And I recognize this may seem a little simplistic, me asking in 30 seconds, what is CADA? What I'm trying to do is just make sure we're all really comfortable with, beyond the legalese of it, fundamentally, what is this law trying to do? And therefore, as we talk about where does it need rewrite for clarity, how do we understand it? So I'm going to go to Tom Aker, and then to Alana, and then to Tom Wheaton.
This is Tom Aker speaking. I guess I'll try to maybe give input on both. The grocery store, I would say the CADA is the Colorado discriminatory act that protects everyone equally, especially those that do have disabilities to gain access and enjoy the same rights as everyone else. One of my aha moments, and I would echo Lauren, I'm learning a lot, but there's a lot more to learn, at least for me. Some of the things that I've picked up on that I need to learn more about is some of the definitions and how they were determined. Take age, for example. I understand over 40 as a protective class, but from being protected against discrimination, I don't think age matters. So maybe defining that a little differently, and there may be some other definitions as well, but I don't know the ins and outs of how things were determined in the first place.
Thank you, Tom. We go to Alana, Tom Wheaton, and then we'll continue on. I'm just looking around my screen, but let's go to Alana and Tom Wheaton, please.
Awesome. This is Alana representing business interests. And the way I describe Kata in grocery store, talking to a friend, is that it really ensures everybody's right to employment, housing, and public accommodation, which I would rephrase as just kind of general life activities, regardless of disability or not. So basically, whether or not you have a disability shouldn't impact what you're able to do, whether that's go find a job, where you want to live, or if you want to go to a concert or just read a dang website online. And also, I'd just kind of add that something I've been thinking about as we've been having all of these discussions is that I guess kind of disability or folks with disabilities are considered a minority, but it's a minority that we're all presumably going to spend time as part of, whether we age into it, something happens, or it's just like a temporary stop on the way back to other parts of life. Yeah, thank you. That's what I've got.
Thanks, Alana. I'm gonna go to Tom Wheaton and then to Cindy. And then Courtney, if you're in a place coming out of court that you're able to speak, I'll go to you, but I don't want to put pressure. But Tom Wheaton and then Cindy, please.
All right, thanks, Barrick. You know, when Jenna was speaking, I glossed over and couldn't write down in time the time to file a claim for the public accommodations. Does anybody have that? Was it 60 days or 160 days? What was that? Do you guys know that?
Let me pull Andrew in on that.
Yeah, it's 60 days for public accommodations.
Yeah. So to me, that was the most glaring, is that we had the three main areas of this, right? You got employment, housing, and public accommodation. And like we discussed last time, I think Ian may have brought it up, or Andrew. It's amazing how we have the three different deadlines for those. That, and I think 60 days is absolutely ridiculous, a low number. So that was my biggest takeaway aha moment. And then the other thing I think is I've personally been focused on disability rights and just things that come our way for the last decades that I've been involved with this personally, but also a lot of my peers throughout the country. And to see all the other protected classes, I'm still trying to absorb just the breadth of all that, and wonder. The thing that came to my mind was wondering if everything was represented. Sounds like there's been a lot of work into this for decades, and I'm still learning personally. I'm still learning about. Age is 40 plus and he's protected, and the various other areas that I'm personally kind of unfamiliar with. But like somebody else said, we all have a need for this equal opportunity to thrive, whether it's employment, housing, or in my case, I see the most of it as a public accommodation where I feel most violated. So that the elevator pitch or at the grocery store, my thought is it kind of encompasses a lot more than just the disabilities. It's everybody in Colorado that will enjoy life to the fullest.
Thank you, Tom. Cindy, and then Courtney, if you're in a place.
Yes, Cindy, I just wanted to follow up on something Tom said earlier, and you guys kind of alluded to, which is the piece around age and protected class. I don't know if this is language that's already in the ADA. And I guess I'm trying to clarify, is there a question about should people over 40 be protected, or why is that? I wasn't clear when Tom made that comment. So I wanted to clarify that before I made further comment.
Thank you. Ian, please jump in.
This is Ian Kelmanowitz. I can briefly answer that. With just some of my knowledge from the employment context, Congress made a decision at the federal level in the 1970s that older people were at risk of losing their jobs or losing access to federally funded programs because of their age. And in particular, Congress decided that older people are more vulnerable to the old age risks of losing employment. This was back when people still had real pensions, retirements, that if you lost your job, you would wind up losing those benefits as well. And the idea here was to protect those individuals from losing their jobs or under a different federal law, losing their access to federally funded programs. Why they settled on 40, I don't know. Once I turned 40 and became protected from age discrimination, I didn't feel any different than I did when I was 39. But that is that is the number that was settled on at the federal level, and so that's the number that is in CADA as well. And I'd add, just for everybody's, I guess, amusement or edification, that it only works one way. You're only protected from age discrimination if you're over the age of 40. You are not protected from age discrimination because you are under 40. So if you're too young, you don't have any protection. Only if you're too old, air quotes, for being over 40, because I don't think that's very old.
Okay, so well, this is Cindy, and I appreciate you clarifying that, because I think there's two things, and one is that it's not unusual in the workplace, particularly, for there to be issues around age in general, too old, too young. But I have just in the last year and a half, had a number of folks that I work with, both government as well as private, who've experienced a lot of discrimination to the point of retiring because of age and lack of knowledge of the changing technology. In other words, they weren't brought up with that. And rather than an employer saying, our responsibility is to train you because this technology's changed since, we started when you started, whatever, we started 15 years ago. The typical approach is more, well, you're not keeping up, sort of thing. So I'm hoping that we maybe can strengthen that. But I also think that we have to recognize that folks who are young often see that age discrimination as well. So I don't know if there's a better way to phrase it. I realize we're kind of looking to the federal law. I don't know about the age 40, to be honest with you, but I think that when it comes to technology awareness, it's a huge issue in the workplace, no question.
Cindy, I appreciate you raising this, and Ian, the thoughts. What I'm going to do is make sure that Carrie and I capture this as one of the topics for some dedicated discussion around how Colorado's law intersects with the federal ADA, and if we want to have a conversation under that charge of ours to clarify. I do also want to just flag to this group, somebody was very quick in doing some quick research to support me here. And again, this is not providing legal advice or opinion, but looking at the bill that created this subcommittee in particular, 2434-10031E does say that that this subcommittee can report findings on any other issue related to accessibility and the civil rights of persons with disabilities. So while this is not me giving a legal opinion that you're instructed to, I think this group can take that language to our conversations, that the CADA itself is the floor and not the ceiling. And we should really be focused on the outcomes we're charged with, which is clarifying, ensuring enforcement, and ensuring the protection. Courtney, are you in a place where you can talk?
Yes.
Okay, did you happen to hear the presentation we had, or were you still in court while we were doing it?
No, I was still in court, so I came on like right before you mentioned everyone that I was on. I had only been on for like 2 minutes at that point.
Then you will not be subject to my pop quiz, but I will invite you into the remainder of the conversation. What
Thank
I'm
you.
going to, of course, thank you for joining us as you're coming out of court. I'm going to move us into the conversation about the topics we've identified. And what I'm going to do is read off some of the topics we captured from our last conversations that this group identified as needing to be addressed during our conversations and possibly included in our recommendations for rewrite. I'm going to ask two things as you listen to these. Number one, are we missing anything? I guess I'm going to ask three questions. Number one, are we missing anything? Number two, does my description of them leave critical detail or nuance that needs to be added? And number three, I'll ask you to start thinking about, for part two of this conversation, which ones we may be able to make some traction and get some traction and progress on over these next 20 to 30 days. Is there something as simple as, let's include this definition and we think it's straightforward? And which ones you think are really going to take some in-depth work? So if you'll indulge me, I'm going to read them for those that don't have them in front of you. But these are the issues that we captured. Plain, easy to understand language. The need to address damages for emotional distress, including quantifying damages and any other considerations. We need to address, some folks named, what to do about caps and modernizing from the 1990s dollars that govern. What types of accountability measures? What, if any, education should be taking place? Is there a need to define qualified individual? Within the public accommodation laws, incorporating the 2010 DOJ standards for accessible design into state law, and somebody else mentioned, as Texas has done. Extending timelines for people filing claims and uniform standards for exhaustion. We just heard the call out that there was 60 days on the public accommodation, there's 1 year on housing, and 300 days on employment. It was identified the building burden onto the approving entities, such as building departments and code enforcement, to pay attention to the details when it comes to the enforceability. The need for data resources related to litigation, and the desire by this group, some members flagged, to look at other states' best practices and pull together some research and resources of what's been done in other states to better protect the rights of those with disabilities. So my first questions before we go into staggering these and tiering them into what we can address quickly and what's going to take more discussion. Are there critical things that were missing from the list that Carrie and I captured? Are there things that you would add in light of conversations or just thoughts that you've had since then that you want to make sure this group adds in? And I want to be very clear. We're going to be getting together like this for the next year. So if you miss it today, there's still opportunity. We're just trying to capture as much as we can in this list right now. So I'll open it up to a raise of hands or just coming off mute, no formality, and I'm not going to start calling on people, but are there things missing or things you would add to this list that we should include when we're talking about clarifying, ensuring rights are protected, and ensuring the enforceability? Alana, I see your hand up.
Yeah, thanks. One thing I would either add or make sure, it may have been on the list and I might have missed it, but not just education from the perspective of making sure everybody understands the law and why it is important, but also education from the perspective of making sure any of Colorado's kids or youth that are in the process of going through the education process are getting all of the accommodations and resources that they need to make sure that they're basically being set up for success and not just having a terrible time in school.
Thank you. And I see you're going to hear me make this reminder throughout all of our calls. I see we've got somebody other than a subcommittee call member on. We welcome members of the public on every subcommittee call. Our only ask, and I see you're honoring this, is that you leave the cameras being on to the members of the subcommittee and the staff supporting it. And we do reserve time at the end of each meeting for public comment. If you would like to make public comment during this meeting, this is the one time that I will ask you to go ahead and use the chat and just drop me a note in the chat that you'd like to be called upon during public comment. But we reserve time in every meeting. So we appreciate anybody joining. Courtney, I see your hand up.
Yeah, I think in addition to addressing timelines, for exhaustion and things like that for administrative remedies, I think another thing, and you may have said it and I just missed it, was are we gonna, is there a need to give like a notice period or a right to cure period for whoever is potentially in violation before, civil remedies could be pursued?
Thank you. And I did not have that on the list, so we will add to the list a discussion of right to cure and any provisions this group would like to discuss surrounding that. Next, I see Cindy's hand up.
Sorry, this is Cindy. I was trying to get my screen reader to be quiet so I could talk. All right, so I guess when I'm looking at the list that you sent out with the agenda, I see accountability, but I'm not seeing enough about accountability, and maybe it's obvious to everyone, but I'm thinking accountability and enforcement. I hear you saying that, but I'm not hearing the strength of it, because I think it's an area that we're going to have to spend more time on in general, and we may have to look at, what can we do within CADA and what other things are we going to have to do that may be outside of CADA. As I mentioned before, service dogs, enforcement around that is just one example, but there are a number of things. So I'm just wondering if we need to strengthen that a little.
Cindy, I appreciate it. I'm actually going to keep you on the mic if I could for a minute. Consider enforceability added as a topic, and I think you're right to call it out. It's one of the three things we are specifically told to address is the enforceability. I'd love for you to weigh in if you have specific thoughts on what aspects of enforceability you want to make sure are covered. Are there specific things in sections 4, 5, or 6? Is it all of them? When you think of it enforceability, what are the conversations or the aspects that you want to make sure we include in those discussions?
And bearing in mind, of course, I'm not the lawyer here, yeah. But my concern is that, I understand that much of this is not enforced under the civil rights commission. It falls under the EEOC, which is a very laborious process and so forth. I understand there are some exceptions, but I'm thinking that we need to really take a look at where are things enforced and where do they need to be enforced. Because when we give the example of a service dog not being allowed into Uber, why is that not a traffic offense? I don't know. Maybe it's obvious to the lawyers here, but it's not obvious to me why it's not. Because if I call a police, they can't do anything other than document it right now. It's not a misdemeanor. So I guess I think we need to take a look at where do we need to build enforcement in, and I think we have some gaps.
So thank you for that clarity and that conversation. I think what that suggests to me, some of you have heard me talk about a policy risk analysis flow chart that I'm going to be introducing and sharing with folks. I think one of the checks that you flagged that we can do as we go through any recommendation is simply, how is this implemented? How is this enforced? What does that look like? So that we're making sure that's part of our considerations throughout, if that feels right to you.
Fantastic. Thank you.
Okay. Andrew, I see your hand up. Jump in, my friend.
Thank you. Yeah, this is Andrew. So first, responding to Cindy a little bit. Historically, we have had some criminal penalties put in CADA for people who violate people with disabilities rights, but those have generally not been enforced. In our experience, the law enforcement officers show up and say, well, it's not in Title 18, which is the criminal code, so there's nothing we can do about it, despite there being, misdemeanor penalties for disability discrimination. So, I'm not saying we need to get rid of those or we need to strengthen them. I'm not opining one way or the other, just to mention that those have been tried and so far unsuccessful if we put them in CADA. So to the extent we're going to do so, we should probably look at making some recommendations for putting those in Title 18. The other thing that's missing from the list, not that I'd brought it up before, but in having some other community discussions, is Colorado is kind of behind the times with respect to off-duty usage of medical marijuana. As some of the attorneys on the call know, there was the Coates decision that came out, and I want to say 2012, but several years ago, before a lot of states had instituted medical marijuana programs, that essentially said that off-duty lawful within the state use of medical marijuana is still quote unquote unlawful because of federal law. Since that time, a lot of other states have come out with opinions that say that off-duty medical marijuana use is perfectly acceptable, if not statutory rights for employees to use off-duty medical marijuana. So what the community is made clear to me is we would like to look at that, see if we can't build in some protections for lawful off-duty use of medical marijuana. And frankly, since Colorado is, leading the way on medical mushrooms, potentially incorporating some of that as well. Again, not opining one way or the other, but that seems to kind of be a glaring issue that we may face in the next, several years. And it'd be great, at least with respect to marijuana, to put Colorado back on the cutting edge rather than, at the back of the pack with unlawful use.
Thank you, Andrew. Cindy, your hand is up. Is that a new hand raise or is that still there?
This is Cindy. No, it's because when I put it down, I have to listen to the screen reader. So
No problem at all. No problem.
I did want to respond if I could, just briefly, to what he said. And I just wanted to say that I think it's, conversations that we need to have around enforcement and different areas in general, because as I was doing research, I realized that Colorado doesn't have nearly enough in place around things like telehealth and what the medical practice in general should be doing and so forth. And some of the other states have done a great job of it. So it would be nice if we really expanded the conversation around what areas need to be looked at, maybe more detailed, and determine where.
Thank you. And again, I want to ground folks in the three key areas spoken to in the bill that created the subcommittee of clarifying, protecting the rights, and ensuring the enforceability. Are there key elements or sections that right now are coming to mind that you think we need to make sure to include in this conversation? Okay, and as I said before, the table remains open. There's no closing the list of issues until next, probably October, when we have a draft of our final report. Where I'd like to pivot us, though, then, is the report that we're trying to put out we will be putting out a report in December. Let me be very clear. This report will contain two things. One, it will contain where we think there are some, if any, actions that could be taken in the short term. If that's as simple as dates, definitions, or clarifying kind of bill cleanup issues that we think in the next 1 to 2 meetings, we could get to agreement on. Otherwise, the bulk of the report is going to identify the issues that we are going to be working through and some of the challenges we see in them and what our process and approach is going to be to making sure we hear as many perspectives about them, get as smart as we all can, and then become as aggressive or as ambitious and aspirational as possible in ensuring Colorado continues to lead nationally, and in this case, on protecting civil rights. So I would invite folks, are there any issues that you want to say right now? Barrick, I think with a 30-minute conversation, we could actually find some common ground on this. Or Barrick, there is absolutely no way in the next 5 meetings, and you better plan 15 just to get through this. Are there issues that you think are particularly tough, contentious, or issues, hopefully, that you think we can find some common ground on pretty quickly? Andrew.
Thank you, Barrick. One thing that I think this is going to be fairly low-lying fruit is the definition of qualified individual. It cites to a federal definition that simply does not exist. I think we all know what we're talking about. Federal law is pretty clear. If we can just kind of wordsmith a little bit and get rid of a reference that doesn't exist in federal law, I think that would be fairly easy to do and not very contentious.
Thank you, Andrew. Other thoughts on any of that low-hanging fruit? And I want to be very clear. If it's there, people, we will jump on it, but I don't want to feel any pressure, you to feel any pressure that we need to tackle something sooner than you're ready to feel informed and have the right conversations. But is there anything else that you'd like to prioritize that you think we might be able to make progress on in the short term? Tom Aker, please.
In line with plain, easy, understandable language, maybe looking at the definitions and seeing if they need to be wordsmith in the entirety.
Okay.
I point to what I find troubling with age. I recognize the over 40, but I think some things may apply to under 40 as well.
Fair enough. Thank you, Tom. other thoughts on issues we may be able to move more quickly to some consensus on? Okay, what I will do is a couple of things. One is we will pull from statute the section in the up front of each that has the definitions, and we can use that as the baseline for some conversations going forward. I'm going to pivot a little bit though to ask the next big question. We're not just here to facilitate, we're here to make sure you have all of the resources, the information, the research or expertise and perspectives that will be helpful for you to be able to make informed recommendations and have the robust conversations. So I'm going to ask you to think about that list that we've been discussing of issues. Everything from the time to exhaust remedies and the arguments for or against any adjustments, the things like emotional damages, things like the definitions or incorporating standards. On any or all of these, and feel free to give me an exhaustive list, what do you need to make more informed recommendations or to have more informed and fact-based conversations about these issues? Who would you like to hear from if there's additional lived experience or expertise that you'd like to hear from? What type of research can we bring to all of you to support these conversations? Tom Wheaton.
Oh, thanks, Barry. We mentioned about best practices or something that's been out there by other states. I think Texas was brought up. Can we get a research on the other states as well to see if anything has popped up there? I would really like to be able to read and absorb all of that to see what was actually successfully put into place for their respective states.
We can. Let me ask you some questions. We are in the department is in the process of hiring somebody to support us with some research. We're also happy to do some basic research. Are there specific states that folks have an interest in? And if not, we can start with some high-level scans. And once we have this conversation about states of interest, then I'll bring Cindy into this conversation. Alana, were you raising your hand about the states or different now? Okay. Feel free to drop me an email or a text. Andrew, maybe you have some words of wisdom for me on what states we should dig into.
So I will say, Texas has been mentioned. That's definitely a good one. California has been at the cutting edge of a lot of this as well. With respect to the medical marijuana thing in particular, Massachusetts and I believe Rhode Island also have some pretty good statutes that might be worth taking a look at, if not court decisions as well.
Okay, thank you. And continue to feed us suggestions, and we will pull, both current statutes, but also any recently introduced and passed bills, so we see where those trends have been. I'm going to go to Cindy. Andrew, please.
I'm sorry. One more thing popped into my head. I had a meeting earlier this week, actually, with someone in Washington State who they're kind of doing something similar to what we're doing. They're trying to rewrite their state statute with respect to people with disabilities. So there's not, pre-existing stuff out there, but it might also be worth keeping an eye on the state of Washington.
Great. Thank you. I'm going to go to Cindy and Alana. Ian is my other lawyer on here. Or one of the others. We were just having the question of other states that we should be looking at. So if you have thoughts, drop me a message and we'll pull some research on what they're doing. But I'm gonna go to Cindy and then Alana for thoughts on what can we bring to you or go identify that would help you to have these informed conversations. Cindy?
Cindy, so there's a couple of things. First of all, I'm not sure when we talk about what's existing federally versus in state, I'm not sure that everyone's familiar with all of the resources and or statute and history available under the United States Access Board, but it's a great place for people to go, and it breaks down a lot of history and a lot of information about federal law as it applies to not only the ADA but physical barriers and communication accesses and information communication and technology specifically. So I'm just thinking it would be helpful to make sure that that's available to everyone, depending on their background. Not everyone has had a chance to really take a look at what exists federally anyway. We see some reference to it in our CADA, but we don't really, people don't necessarily work with it unless they're an attorney or have some reason to do so. when it comes to states, I really believe it depends on the specific protected class or disability and or special interest. So, for example, there are some states that do a really great job how they line out in statute rights and so forth for folks who are maybe deafblind. Other states, it's for deaf. And so I think that we have to take a look at all of our different best practices and utilize the skills of the folks who are here to give that information to you guys to kind of vet. I think that would be helpful. I know I sent you guys some resources around some best practices around language and how you refer to people, which we really don't have anything in our law here in Colorado. But I just think that we all have something to bring to the table when it comes to this, and it's not going to be any one state.
I appreciate that, Cindy. And we'll get into in next steps how we're going to approach it. But our intent, kind of picking on what you just said, is to identify in advance what the more narrow issues are that we're going to be discussing at upcoming meetings, so that members of this subcommittee can spend time thinking, doing research, talking with friends that you know, and sharing with us to distribute to the group different resources related to that narrow topic, rather than us just saying, we're going to talk about all 20 of these. What do you think? We're going to get much more focused on these. We just wanted to first see where the sequencing looked like, but appreciate your suggestions. Alana.
Thank you. Yeah, a couple things that popped for me from today's discussion specifically as things I'd like more context on. One, just in general, would it be possible to get a copy of today's slides? I always like taking notes and I couldn't write fast enough today. So if that would be possible, that would be awesome. And then both around the reasonable accommodations and also enforcement of the law, it would be nice to get more context of what's been tried before and whether or not it actually worked. I know someone mentioned that I think misdemeanors had been added in, but they weren't enforced. So, what's the point? And especially with enforcement, I'm uncomfortable with civil punishment. That may not be the right word, but misdemeanors, anything involving jail, just because I'm comfortable with the concept of jail and prison in general. Things like volunteer or whatever, giving back to the community you have harmed seems more useful than sitting in a small room, but that's probably off topic. And then the last question I had, just because it occurred to me as I was raising my hand this last time, if folks are using screen readers, do they get a notification that I or someone else has put our hand up? And just because I would like to know, so I make sure I'm not doing that over top of someone saying something particularly important part of their sentence, something like that.
I do not know the answer to your last question. I'm going to ask Cindy. Cindy, I believe you're using a screen reader, and Alana was just asking, when somebody like her raises their hands, is that something that gets flagged or called out by your screen reader?
Well, I want to say that it does depend on what platform one is on. Typically, it is possible for the screen reader to say that hand is raised, but it has not been consistent with Zoom. It is consistent that it will tell me if someone has come in or left the meeting, but not necessarily with a raised hand.
Thank you.
Thanks. And on the note of some of these resources, I just want to mention, it was flagged to me that a lot of the things around the emotional distress damages, those conversations are coming in large part because of the Cummings decision, which I think most folks on this call are familiar with. And there was a pretty comprehensive report put out by the National Council on Disability about some different approaches. So we will pull that and make sure we can find an accessible version of that as one of the resources that we share with folks going forward. Continuing this real focus, though, on what you need to learn, and I'll open it up because some of you have more daily experience and exposure and expertise. Some of you are coming at this from, I live with the realities of having a disability or of running a business, and I want to make sure I'm doing things right. So I'll ask, what is it you would like to learn? I'll also put to our more daily experts or those folks who deal with this on the daily basis, what do you think others should learn to be able to have these kinds of informed conversations? And in a moment, I may start calling on people because I do want to make sure that I'm hearing from everybody about what you need to be learning or hearing to have informed conversations about some of these conversations, like timeline to exhaust remedies, or issues around emotional distress caps, modernizing from our 1990s dollars. Ian, your thoughts?
Thanks, Barrick. Ian Kelmanowitz. I guess one of the things that I would like to help other people learn is what this process really looks like in real life for the people who get involved in using the law to protect or enforce their rights. We can talk here in the abstract about a 60-day window for exhausting or a 300-day window for exhausting. But we don't also talk about what happens once the charge is filed, how long the charge sits when it's being processed by the Civil Rights Division, what the Civil Rights Division does as part of its investigation, what the outcome of that investigation looks like, how that outcome may or may not impact the willingness of the charging party, the person who filed the charge, to go forward, with potentially litigation to enforce their rights, what the litigation process looks like at the state court level or the federal court level. I think it's important for everybody to kind of get an idea of what this looks like from the perspective of a person who's gone through this process. So that way, when we're talking about enforcement and we're talking about remedies, we're not doing it necessarily just in the abstract, like the statute says you can file a charge of employment discrimination within 300 days. And after 180 days of filing, you can ask for a right to sue letter and file in court. But to actually talk about what this all looks like. So, we are all kind of, I come at this from the perspective of somebody who's representing individuals with disabilities in litigation over employment disputes. I don't have that lived experience of being denied access to a place of public accommodation because of a disability, or being denied a job because of disability. But I've been doing this for a long time and have been able to, learn from my clients about the process. And I think that would be something that would be helpful, I think, for the folks who aren't necessarily involved in the enforcement side, the litigation side of this, to understand what this process looks like. One of the things that I think about in terms of a question I'd like to know, and I don't know if this is appropriate to ask or not, but I'm going to ask it anyway. I think it would be good to know if there are really any sort of like third rails that people are unwilling to touch. If there is, if somebody has, as we're working through all this and trying to come up with these fixes, if somebody has a position that they are just like an absolute hard no on, and by way of example, Lana's comment about, not being really fond of the idea of prison as a way of dealing with discrimination. I think the notion of criminal penalties for certain types of discrimination are appropriate. I don't know that I agree that prison is appropriate. And, I do wonder if it's appropriate for the subcommittee to kind of have that conversation, like, hey, this is something that I absolutely could never get behind. But I'll leave that more to you and Carrie as our facilitators.
I appreciate that. And I will tell you, I approach my role that my job is to find what are the issues that somebody says there's no way we're going to find agreement on. And I'm going to elevate that until we do find that agreement. But if there are things that we have folks who say, I'm just never going to be on board with something, I would love if you would reach out to me so we can have a conversation and I can understand a way to incorporate that into our subcommittee's work. But until or unless somebody flags that, and I want you to feel very comfortable doing so, my job really is to push people to feel uncomfortable. I think we're going to have some interesting conversations among folks that say every remedy should have 1 year, to some folks that say that's going to open up the potential for frivolous actions. We're going to have people that talk about emotional damages and malice versus ignorance. We're going to push through all of those. But Ian, if you think of something where you say, I could just never be on board, and maybe it is on that enforceability arm. And I think what I'd like to do is get us to identify what do we need to clarify, because that feels like the easier conversations of where do people either in the public, private, or just individuals feel that they don't understand what is expected or they don't understand what their rights are. And let's go after those. Then we're going to move into the conversation of how do we ensure the rights. And finally, we're going to have some conversations, absolutely, on each recommendation about what should be the process of enforcement. Who should be charged with it? What should be those remedies? And there's tools at their disposal. So I don't want to at all just, do away with the thought there could be something off the table. I just come to this saying everything's on the table until you push me away from the table. Andrew, see your hand up.
Thank you. So following up on Ian's comments, I think something that would be helpful for me in particular, and I think all of us to understand, is really the role of administrative exhaustion. I know in some instances, such as in the employment context, where there is kind of an interactive process that can take place, it can be critical. But in the world that I live in public accommodation and public entity discrimination, there is no exhaustion requirement. We fought pretty hard, actually, the last couple of sessions to get that removed from the law, so that it's more in line with the federal law, so that people with disabilities who've suffered discrimination by public accommodations or public entities don't have any sort of exhaustion requirements. They're able to go right to court. And, I think that's appropriate given the type of discrimination that it is and where federal law is on that question. But I do understand that there are some contexts where it may be important, if not critical.
Thank you, Andrew. Other thoughts? And again, this topic remains open. And this is one where I will particularly invite, if not plead with you, to drop Carrie or me an email and say, hey, this issue I need, and do it based on today's conversation or the next time we send out an agenda, flag to us and say, I'd really like to better understand, or I want to hear more perspectives about this. I think the governor's office and the department did a yeoman's job of trying to make sure we have diversity of perspectives. But we only have who is on the subcommittee. So I want you to not only push us as your facilitators on what expertise or research you need, but if you tell us, hey, I want to hear more perspectives from those living with a physical disability or those who operate a business and have been defendants, I want you to tell us who you need to hear from to get perspectives as well. Any other thoughts, though, at this time, given this list, and I'll read through it again just real quickly, of plain, easy to understand language, emotional distress, including damages and other considerations, caps and modernizing of the dollars, accountability, and we're now here adding to this list enforceability, the need for education of all, defining qualified individual, the public accommodation laws, including the 2010 DOJ standards that Texas has adopted, the timelines for filing claims, the process for exhausting remedies, the building the burden onto the entities who are approving things like building inspectors and code enforcement, other state best practices, and the need for data resources related to litigation. For any of these or other things that are on your mind that you're going to reach out and share with us, who else do you want to hear from? Whether they're experts or people simply with a different perspective. Ian, jump in, and then I'm going to give everybody a heads up. I am going to go around the room, and I'm going to ask you to name for me two voices, perspectives, whether they're professionals, whether they're individuals, or whether they're constituencies, who you think voices need to be heard by this group. Ian, you jump in though.
Thanks, Barrick. Ian Kelman-Woods. Following up on Andrew's comment about administrative exhaustion, and I'm looking because just of where Aubrey Lennis is on my screen. I do think it would be good for us to hear from somebody from the Civil Rights Division who can give us sort of a similar presentation like the one we got this morning at the start of our meeting from Jenna Anderson about the exhaustion process and what happens. So that way, I mean, I know what happens, and I know, when people talk about, oh, well, we went to the CCRB and they made a no probable cause finding, that in my world doesn't mean anything. because I know how frequently these no probable cause findings get made, and I know how these investigations get done. But I do think it would be helpful for the committee to hear about that, and in particular to hear about what I would say is the amount of enforcement that gets done by the Civil Rights Division and the state in these cases, so everyone can understand the role that the, sort of the ability to go to court, like Andrew was talking about immediately, plays in this process as sort of the, what we in the law refer to as a private attorney general context. So I think it'd be helpful to hear from the Civil Rights Division. It doesn't need to be from Ms. Alenis, but maybe one of the investigative supervisors or, somebody there who can, talk through what the process looks like from start to finish, so everyone here can have an understanding, of what that is.
Thank you, Ian. And I'm not going to put Aubrey on the spot, although I see her nodding. Yes, I will get with Aubrey and we'll figure out who and what that scope of a presentation could be to understand that process and the role in the numbers that they're dealing with. We've got about 8 minutes. I'm going to hold the final 3 minutes just on next steps. I'll remind if there's anybody who wants to make public comment, we do welcome that, and you need to drop me a note in the chat to let me know. We don't have any yet, which means I'm going to continue this conversation, and I'm going to start with Tom Aker, then I'm going to go to Lauren Schwartz, and then Alana. And I'm going to ask you all, what voices, what perspectives would you like to hear from the public or from different groups to help inform your conversations?
Tom Aker, I think if we're talking about building the burden upon approving entities, it'd be good to hear from more of the engineers and architects on what they're including or looking at when they design a building or retrofit a building, so that we know what's possible and what may not be possible. And then I guess personally, just more from the legal standpoint of what some of our simplification may do, or make it easier to read, how it could, making sure we're not conflicting with the federal ADA with what we're doing.
Thank you, Tom. Lauren, and then Alana, and then Tom Wheaton. Who would you like to hear from to get more perspective?
I would second what Tom just said, Tom Aker. So thank you for that. I think if you're, oh my gosh, I mean, start with any one of these topics, maybe some organizations that have a national perspective, like one that comes to mind is Colorado SHRM, the Society of Human Resource Managers. How does this look, and get their expertise in this. And looking at when we're thinking about caps and changing dollar amounts, I think it's important to hear from some perspectives of what that could really mean. That might be, we'll just add on to that. It's not part of the question, but hard no for me is lifting all caps. So if you obliterate a public accommodation, you can't really provide basic access to that public accommodation. So maybe hear from some organizations that can give you some perspective on that.
Thank you. Alana, and then Tom Wheaton, and then I'll go to Cindy.
Thanks. Yeah, what I'd really be interested in is hearing, I think, from, as kind of others have said, activist groups, and then also maybe folks who are internal and have seen how the laws we have actually played out for impact to the communities, and kind of the gaps for expectations of how it would work versus how it is actually, the impact is actually happening. I know that the group as a whole seems very interested in sort of intention versus impact, and I think ideals versus reality. So I'd be really interested in learning more of what the ideals are, of what the absolute best improvements that could possibly be made, regardless of anything else, where that is, and then seeing what's actually realistically possible out of that, if that makes sense.
Great. Thank you. Tom, Cindy, and then Courtney.
Okay, Tom Wheaton. piggybacking on what Lauren suggested, I think national resources would be helpful. And I'm trying to think of kind of national advocacy groups. Certainly the one I represent, the Paralyzed Veterans of America, has a lot of resources, but I'm trying to think of other like organizations like that, to get their perspective. And then also, can we get a perspective from an ADA regional representative that might have some advice to us on the 2010 updates and maybe even some statistics as to what's been successful or what has been attempted as far as remediation at various levels. I'd be curious to see those statistics.
Thank you, Tom. Cindy and then Courtney.
Yeah, this is Cindy. I think we need to hear more from folks who are impacted specifically in today's world in Colorado by lack of accommodations, and, you know, particularly hearing what they're going through and, you know, if any recommendations they might have. I know I brought up service dogs before, and I brought this up because it's just the simplest one, but it's such a big deal that literally every time I'm with someone, and they're trying to get a Lyft or an Uber, more often than not, they're passed up at least twice before they can schedule a ride. That's insane, and it's unconscionable, but it's real. So there is a subject matter expert who actually has been working with the university and collecting information. We're going to publish a paper, and it might be helpful just to hear from them because they've collected so much information. But I think just hearing from folks with some specific areas that we know are problems with specific access to public accommodations would be helpful.
Thank you. And Carrie and I may well reach out to you, Cindy, about that person doing that research, if it's okay. Wonderful. Thank you. Courtney, any thoughts on who you'd like to hear from?
Yeah, I mean, I think from a public accommodation standpoint, it would be good to hear from either, you know, individual business owners who can sort of speak to how they've been impacted by these laws and lawsuits that have stemmed from them, and or from like chambers of commerce and restaurants association, like, you know, groups that oversee small businesses in our state, and you know, get some insight from them, as well as like hear from somebody or some organization that can talk about this education piece, like not just the people that would be providing that education or providing that sort of expert level insight for these groups, but also what do these groups, like, what do they need to know? What do they need to be? What would facilitate their being educated in order to make, you know, businesses aware of what needs to be done with the laws? Like, how are we going to actually get this information across to the people who need it once this law is revised?
Understood. Thank you. I appreciate the suggestion. We are at 1 minute until the hour. I'm going to get us all out of here on time. Really appreciate the conversation. We're all back together in 2 weeks, and that is currently scheduled to be our final meeting. It's the final one we have on the calendar for this calendar year. I'm just going to tell you right now, we're going to reach out to all of you and see if it makes sense to try to squeeze in one more conversation in the event that we want to put some things forward in this December report that require a little more conversation. In the meantime, we'll follow up with all of you. We're going to pull together, as I shared it during the conversation, that list of definitions in CADA, so we can circulate those and see if that's the basis of conversation. I will ask all of you to give some thought to whether you think there are things that could be reached, we could find consensus on as early as the next few weeks. If not, that's fine. We've got plenty of time to work. But if there are areas you think we can, drop me an email, give Carrie or I a call or a text. Otherwise, we'll send that out. We'll get information out a week in advance for our December 4th meeting. If you are celebrating Thanksgiving this week, I hope you have a great time with whoever you're gathering with. And whether you're celebrating that holiday or not, I hope everybody gets a day or two away from the madness of traffic and offices and all of that, and you get to unplug for a little bit. We're thankful for the opportunity to work with all of you. We will see you again on December 4th. Thank you all for your